Hi everybody, trademark attorney Josh Gerben. I'm here to talk about what is an intent to use trademark application. So an intent to use trademark application is a trademark filing made before you actually have any sales of your products or services in the marketplace. So let's go through why an intent to use trademark application can be beneficial, and then let's talk a little bit about how an intent to use trademark application is a little bit different than an in-use trademark application as far as the overall application process is concerned. So there are three reasons that an intent to use trademark application can be extremely beneficial. The first is that the filing date of your application can become the federal priority date in your trademark. The second is that you can get a government review of your trademark application to determine if the government thinks there's any conflict before you even get your products or services out in the marketplace. And the third is that you can reserve rights on your trademark in a broader scope of goods and services than you may initially intend to offer in the marketplace. So to walk through these points a little bit, the first is that you can get a federal priority date on your trademark by filing an intent to use application. So if you don't have sales of your products or services yet, by filing a trademark application, that filing date becomes your priority date throughout the United States. So think of it this way. If you file a trademark application on November 1st, 2019, but ultimately don't get it registered until December of 2020, your rights in the trademark will be retroactive to the filing date in November of 2019. This can be incredibly important as you're developing a brand because you can come up with the name, but it might take 6, 8, 10 months to execute and bring a product or service to the market. So you can get the trademark application filed and be ensured that nobody can come to market faster than you and take that name, or file a same or similar trademark with the trademark office and ultimately block your ability to register the name later on. And that brings us to the second reason that intent to use trademark applications can be really helpful. If you've got a little time, you can file the trademark application and actually get the government's opinion on your trademark before you even come to market. So when you file a trademark application, it typically takes about 4 months to get the government to review your application. This is why you need a little time. If you're trying to bring something to market in 60 days, this is not going to work. But if you're 8 or 10 months out and you file a trademark application, in 4 months, you'll know whether the government's going to approve that application or not. And that can be extremely beneficial because before you go out and invest millions of dollars in inventory with labels on it, with a particular name, you can know if the government itself is going to have a problem with your trademark. And finally, intent to use applications allow you to claim a broader scope of goods and services than you might otherwise be able to in an actual use in commerce trademark application. So let's say initially you're planning to offer a brand of cookies, right? And we've got a name for it. But you're thinking, hey, you know what? In a year or two, I might actually offer a brand of coffee. I might have other food products. I might even open an actual restaurant under this name. In that case, you can make an initial trademark filing for just the cookies for what you're actually selling, but then file an intent to use application for all those other goods and services. This will help to ensure nobody comes in and takes your trademark in a related or slightly unrelated field while you're working to expand the brand going forward. Because keep in mind, trademarks can coexist across industries. We've got Delta Faucets, Delta Airlines, Dove Chocolate, Dove Soap. So just because you file a trademark for a brand of cookies doesn't mean somebody wouldn't be able to then go make a clothing line out of that brand or open a restaurant under that brand. You may need to file additional trademark applications to cover a broader scope if you indeed intend to get into those different lines of businesses later on. So now that we know how these applications can be beneficial, let's talk a little bit about how they actually change the application process with the USPTO. I've had a lot of clients over the years that think an intent to use application might be a bad thing, but it's really not. It's just as good as an in-use application in most cases. The only thing that's really different about the process is when you get to the end. So if you file an application based on an actual use in commerce, once it clears the government review process, the registration will just issue. If you file based on an intent to use, once you clear the government registration process, they'll come back to you and they'll say, okay, the trademark has been cleared for registration. Now you just need to prove to us that you're actually using the trademark in commerce. And then you'll have to make an additional filing that does have some additional cost to finalize the registration. In our firm, the cost to make a statement of use or proof of use filing at the end of a trademark application process is typically $350 in legal fees and $100 in government fees per class of goods or services. So it's not a huge expense, and a lot of times I tell clients you have to think of this like buying trademark insurance. If you're going to spend an additional $450 on your trademark, but get priority that lasts over the course of a year, think about how much money you're saving as opposed to if somebody came in and took the trademark out from under you, and then you have to start all over again. So it's really not a huge expense, it's not a huge hassle, and you get the benefit of the federal priority from the filing date of your intent to use filing going forward. You just can't beat that. So I hope you enjoyed this video. I hope you're a little less scared of intent to use trademark applications now that you know what they are, why they're beneficial, and how there's only a minor adjustment to the application process by making these filings. I'll talk to you next time.